39.86%. Candidate has taken a percentage বললাম 39.86% was present only on 59 days out of 148 days. ঠিক আছে? And the medical illnesses?
Anxiety, depression, my lord.
Mental anxiety. And the ওখানে flu, dental অনেক কিছু বলেছিলাম. This will be mental anxiety. Anything else? No. Next.
My lord, in all the matters, service may be
8. What is the name? Shreya Poddar?
56%, my lord.
Shreya Poddar. আচ্ছা, অরিজিৎ সিংহ কিন্তু is the petitioner. ওখানে father of the petitioner বোধহয় উপরটা একটা বলেছিলাম, সেটা দেখে নেবেন. Check.
My lord, medical is bilateral polycystic ovary.
যেটা মাইনর আছে সেটা হচ্ছে 7 and 9 minor, আর 6 আর 8 represented by father. Shreya Poddar is 56.75%. এই কাগজটা থাকবে আপনার কাছে. And number of days attendant is 84 out of 148. Medical ground?
Bilateral polycystic ovary.
Page 13, bilateral polycystic ovary. But then what is the problem with this? It is the sonography report. There is some issue, but then she will not be able to attend classes or anything, nothing of that sort. Nothing. ঠিক আছে? পেয়েছেন? Bilateral polycystic ovary. পেয়েছেন তো? Dismissed. Next is Shayani Das. 47.97%. Attended 71 classes out of 148.
They have cited jaundice.
Jaundice must be only for a particular period. Then it cannot be a prolonged type, or I do not know. Illness? Jaundice. For the period 4th July 25 to 28th of August 25. Dismissed. এটা রেখে দেবেন. এটা এখানে রেখে দেবেন, এটা রেখে দেবেন. Keep it here.
Item number 1, my lord, I am appearing on behalf of the petitioner, my lord, virtually.
Yes.
My lord, the only correction needed is the in the first para, my lord, the jurisdiction of Kotwali police station district, it is written as Darjeeling, but it would be, my lord, Coach Bihar.
At the time of dictation, you did not let the know. The order was uploaded immediately only to prevent these matters coming over here for correction.
My apology, my lord.
And you could have got it corrected in Jalpaiguri itself. Why has it come here? Should be Kuch Bihar. Yes, next.
Grateful, my lord.
প্রথম দায়িত্ব তিনটে কিলো দেখলেন তারপর
Lordship, in item numbers 2, 3, and 4, I represent the state in this matter.
All right.
Lordship, can you take up item number 4 first?
There were direction for filing reports in all the matters where I filed the report.
Let me see. Four.
ওটা আগে করবেন কি আছে ওটা স্পেশালিটি ভালো ওটা
Yes. Extension of time for recommendation letter expired 2 years back. Yes. Dilip Bormon.
well when I filed the report
Did you get a copy?
Yes.
Would you want to file an exception? No. What is the point?
the point has been decided by the division bench and possibly my learned friend does not have much of a case anymore.
All right.
That is what I've understood.
That was not the point decided by the division bench. That was yeah, my lord, what has happened? I was the teacher of 9 and 10. And my lord, 2016 selection process was initiated, and your lordship knows, 3rd April 2025, the judgment was delivered. Our appointment gone. Now, my lord, one wrong we have committed, but we have been selected in the 128. But my lord, the appointment was given to me. I prayed for extension of time because I was under impression. Everybody was under impression that may go in our favor or may go against us. Whatever it may be, that's why that is the only reason that I could not join. Now, my lord, I prayed for extension of the time. The rule says that the 150 days, 90 days, and thereafter 60 days, the commission can extend. We made an application within 90 days, and some 2 others petitioner within 150 days. Now, my lord, that was not mentioned. Now, my lord, interesting thing is this: the 5 petitioners, there are 3 petitioners are there. 5 petitioners moved the writ petition and 1 writ petition. Now, my lord, the 2 of them got the relief. I have got the court's order. 3 of them got the release by the coordinate bench, and the other, my lord, it has segregated to the Jalpaiguri circuit. Jalpaiguri circuit passed an order for consideration by the School Service Commission. They rejected the prayer. No, it cannot be because the extension we are not exercising our jurisdiction, not the extension. Now, my lord, the decisions of the chairman is under check. Now, my lord, the report is same prayer, same thing they submitted. Your lordship kindly have a look to this decision of the chairman School Service Commission first. If your lordship kindly checks up.
আগে পরে করে দিলে না বুড়ো
Page 40.
বুড়ো একটা
Yes.
It appears from the second paragraph. It appears from the bill of record the petitioner got recommendation letter for appointment for the post of the assistant teacher, the physical education, work education in such and such. Appointment letter was duly issued in favor of the petitioner by the concerned school authority on 2/12/2024. Thereafter, the petitioner prayed for extension of the validity recommendation letter to the office on 4/4/2025, that is well after 90 days from the date of recommendation. The first SLST 2016 rules 2016 as per Rule 73, a recommendation letter issued shall remain valid for a period of 90 days from the date of issue, as per the provision of the Rule 73. If the commissioner thinks expedient to extend the validity of the recommendation beyond the period for 90 days for any reasonable cause, it may be extended for the period of validity for such recommendation later of further period of not exceeding 60 days. So, 150 days. In view of the said provision of the recommendation, it is valid for a period of 90 days from the date of issuance. A candidate who is unable to join within the validity period of 90 days may intimate the commission for extension of the validity of the recommendation letter. Of such intimation, the commission may extend the validity for a further period of not exceeding the 60 days.
This was the PI date.
73 extended permissible only if the commission thinks it is expedient to do so. Reasonable cause is to be shown by the candidate. In order to date 8/7/2025, the Honorable Court has been pleased to direct the chairman to pass a reasonable order strictly in accordance with law. As the above-mentioned provision is the statutory provisions of the chairman is to act strictly in terms of the Rule 73, read with the provision. Hence, the commission is to consider whether there is a reasonable cause of which it would be expedient to extend the validity of the recommendation letter beyond 8 days. Unless there is a sufficient cause, the commission may reject the prayer for extension of the validity period. Moreover, if the total of 150 days has expired from the date of issuance of the recommendation letter, then there is no scope for further extension as per rule. With regard to the notice dated 8/3/2025, whereby the commission has extended the validity period, it may be noted to these candidates who have shown reasonable cause for extension of their recommendation letter. The commission finding it
Yes, I see page 26 is the recommendation letter. It is 22nd of November 2024. And your application seeking extension is page 28, 17th of February 2025.
Extension of the seeking within 90 days, page 30.
All right, page 30.
Page 30.
Hmm.
This is the first letter dated 28/12/2024, which is within 90. Now they have said that after expiry 133 days, this is not the correct. Now the question is this, the identical issue as I said submitted before lordships. 3 of the 5% moved their 1 read petitions. 2 have been segregated.
Where is the order?
That's that order, my lord. I was that order. It is just over there. Yeah, check. There are 5 onwards is the 11 versus 19.
Where is the ratio laid down in the judgment?
No, ratio, my lord, the court said, when it is your lordship can see the paragraph 5 onwards.
Yes.
Now the paragraph 6. In the present case, it is true the petitioner did not join the post of the assistant teacher as per aforesaid recommendation, but they applied for extension validity recommendation within the period of 90 days. When the recommendation was alive in terms of the Rule 73 of the said Rule 2016. Letters were submitted before the Chairman Commission 7th February 2026.
So these are recording of facts. Where is...
Here your lordship kindly see. Para 7 onwards, it also appears the identical issue was decided in this court in the judgment created in the writ petition being WPA number such.
Show me Nahida Sultana.
Nahida Sultana. Nahida Sultana.
Please, আমাদের ডেটা এন্ট্রি অপারেটরকে বলুন তো WPA 12048 of 25. 12048 of 25.
Now, paragraph 8, if your lordship kindly.
I have seen paragraph 8.
Issue needs to be decided taking to note the fact the petitioner lost job after being appointed assistant teacher and being selected first as daily 9 and 10. Well, one thing should I mention, Melody?
12048. Order date is 11 July 25. Nahida Sultana. Wait, একটু উপর দিকে। Wait. Issue needs to be taken into account. It is the same thing that is recorded. Please come to paragraph 7 of this judgment. Paragraph 7 is writ petition disposed as a special case where it is found. This is paragraph number 9. I don't see any ratio laid down over here. The only consideration was that since the application was made for extension within 90 days,
Yes.
so do it. Where is the law, supporting law?
That is one aspect of the matter. Another matter I'm facing this. I'm extremely sorry that my learned junior is not here. The other copy. If your lordship kindly consider the order of Justice Dipankar Dattu by his lordship then was delivered judgment on matter 2014. Higher matter the ratio. Para 7 onwards. If your
Give the number, it can be put on screen.
One thing, they are not the tainted candidates. In fact, they are not the tainted candidates.
No, that is different. Had they been tainted candidates, they could not have got a chance to revert. So,
And the school authority is also making a request to the School Service Commission for extension. Para 7 onwards, your lordship kindly consider. তোমাদের কাছে পিএস বিশ্বাসটা আছে?
this is a different thing. I have read this judgment earlier and it was applied, but how is this applicable in your case?
Applicability, my lord, there is no paragraph 7 onwards.
Paragraph 7.
The lordship kindly.
Yes, I see paragraph 7. Here the teacher was serving in a different school. He wanted to finish off and then come here. This is not the case.
There, my lord, your lordship kindly see the situations. It is the entire fault of the School Service Commission. I have got no, but the Supreme Court delivered a judgment. I cannot make any comment. However, we have lost a job. We got the chance.
You lost the job in the year 2024.
Immediately, we made an application within 90 days and one of them 150 days. It is not the fact after 1 year.
You lost the job in April 2024. You knew you did not have a job. You took the risk.
No. Your
What
lordship
no?
Your lordship kindly see when. Your lordship kindly see the recommendation was made on November 22nd, 2024.
By that time, you did not have the job.
Yes, and first application for extension on 20th December 2024. I was in the service.
You were in service in view of a stay order which was passed by the court. Your service was no longer there. Your service was set at naught on 22nd of April 2024.
Entire matter was pending. I can't say entire matter was pending before the
That is something different. So you took a chance.
Not
It may be, it may not be.
I appeared, it is not the fact that I suppressed it.
No question of suppression.
I appeared and recommendation was made, and your lordship kindly see when I made an application for. Recommendation was made on my lord 22nd November 2024. And I first application for extension was made on December 2024. It is not the after expiry of 150.
If you can show me that there is something better ratio laid down anywhere, please come.
Then let us come back.
Come back. Report in the form of affidavit filed by the commission in court today is taken on record.
It is entirely question of law to show.
To what extent can the law be applied in this case is to be seen.
I was suggesting if your lordship kindly take a sympathetic view of that. They have succeeded. It is not the fact.
কি বললাম? It is for the commission to take a sympathetic view. What can the court do?
Commission has taken a sympathetic view towards other 3 persons.
Where is that order?
No, the order passed by the commission.
Yes.
Then I will produce before your lordship.
Where are those orders?
Yes, okay.
Maybe possibly in compliance of this order.
In the compliance of this, let him.
Four petitioners came before the court.
Possibly because of compliance of this order, that too in August.
And my
We are in February.
my order passed in favor of us, that was consideration. And this order was accepted by the commission. Is it not the fact the commission?
Let the commission accept, the court will not say anything. But for the court relying on this, it is not possible. কি বললাম? The report is taken on record. Stop. Learned advocate for the petitioner relies on the judgment delivered by the court on 20th August 2025 in WPA such and such, Navamita Nondi and others. Wherein under similar circumstances, the court directed the commission to extend validity of the recommendation for a period of 60 days and permit the petitioners to join the posts in the recommended schools. Stop. Next. Your stand is no.
Yes.
Learned advocate representing the commission. But why are you taking a contrary stand as that of Navamita? You have accepted this order. You have not challenged
Let
it.
me check those orders, but the division bench has now put it at rest.
Show me that order.
Within 90 days, you are to approach and reasons are to be shown. It is not very simple that I come within 90 days and I get 60 days. And our extension, as per the rule, requires written reasons. So,
No, here the petitioner has shown document that application for extension was made within 90 days.
but without any reasons, proper reasons. Kindly see this order.
Only reason was the matter was sub judice before the Supreme.
No, that
Court,
will not
other
do.
reason.
That will not do. Kindly see the reason which was given by another candidate. That is the kind of reason where we will relax.
All right. Learned advocate for the commission relies on the opposes the prayer of the petitioner. Stop. It has been submitted that the issue has been decided by the Honorable Division Bench on 3rd February 2026 in
Chiranjit Patra.
MACT 1542.
ওই একসঙ্গে বাঁচতো
25.
তিনটে ম্যাটার ছিল একসঙ্গে।
হ্যাঁ গো আমার হয়ে যাওয়ার পরে
When do you want to come back?
your lordship keep it the 3rd or 4th week of March. I will be here. for some time.
23rd of March.
The interim order is continuing,
What is the interim order?
but not to fill up the post. The appointment letter was given to us.
All right. The interim order that is subsisting in the matter is extended till 30th of April 2026 or until further order, whichever is earlier.
Yet,
23rd.
Lordship, the appearance of the state may kindly be taken into record.
Certainly. State's appearance.
Grateful, Lordship. Grateful, Lordship.
And
the Lordship's earlier occasion categorically directed that commission to take instruction whether the posted question have been filled up or not. But then the report they have not said so. Although we have a definite instruction, the posted question have not been filled.
all right. Are you filing report in the other matters also? Then the same order can go down.
Grateful, Lordship.
Yes.
Item 2 or 3 at the limit.
All right.
Lordship, can I request the learned senior to supply me the number of the MAT application, Lordship?
Yes, Matt, কত লিখলেন বলুন তো Matt? Matt 1542 of 2025. It will be recorded in the order sheet also.
Grateful, Lordship. Grateful, Lordship.
না 90 দিনের পরে
All the
এসেছে, আমাকে
fixed hearing matter.
এটাই লাস্ট একটা
Okay.
জজের account। আমার মোবাইলে সফট কপি আছে, পাঠিয়ে দিচ্ছি এক্ষুনি। Deeply obliged.
এবার বান্ডিলটা টেনে দিয়ে আমি বাইরে গিয়ে বাচ্ছি।
Grateful, Lordship.
Please, Lordship. And I have already completed my arguments. By way of my lord, written notes of argument covering all the points in 4 cases, that is 397, 340, and 314. All those, my lord, relate to sexual assault case. My lord, this was originally a civil dispute which has been turned into a criminal proceeding. It went up to Supreme Court. Supreme Court was pleased to cause the proceeding. Then the state moved to Supreme Court. Supreme Court remanded back all the 3 cases to a trial court. Now, my lord, in all those cases, charges has been submitted in 397, sexual assault case number 397 on 5th of February 2014. But since from the very beginning, we are making an application for the video footage of a camera which they have not been able to supply, and also, my lord, non-compliance of.
Why don't you take a seat?
But I thought my learned friend has concluded on this. So I was starting, I was
About to start.
about to start, then I saw my learned senior start again.
Give me 5 minutes.
So I'm trying to assess the situation.
My lord, charge sheet 5th of February 2014. There are 77.
Last hearing was took place in August sometimes.
Yes,
First of August.
Yes, but that is why I have created a short flow chart to remind you of the facts. But if my learned senior wants to take it up, my lord,
No. I just make a very short submission within 5 minutes. Give me 5 minutes. Brother, give me.
no problem.
397 case matter was ended in a charge sheet on 5th of February 2014. Today is 2026. From the very beginning, we made an application for the supply of a video footage. Because the place of occurrence is 9A Short Street, which is just behind the house of the police commissioner. It is covered by all all cameras. We wanted that it's a case under section 457, 458, which is called house trespass. Now, from the footage, it could be seen that whether this present petitioner or who is an engineer and an MBA at that point of time, and who was one of the directors of the company had entered into the house, that will clearly give the picture. Till today, in spite of application due to the learned trial judge which has been annexed here, they have not been able to supply those copies. Therefore, the charge has not even been framed. And there are 77 witnesses. Apart from the fact that there are not a single witness to implicate the present petitioners, so far 161 statements are concerned. And my lord, admittedly, the state has admitted that. In paragraph 6 of the affidavit in opposition, they have admitted that he was not present at the place of occurrence. But he is the main orchestra of the entire crime, and therefore he comes within the ambit of criminal conspiracy. Well, my humble submission, if there is no material to connect the petitioner with the alleged offense, well, if there is no pillar of a house, how a house can be built up? If I have no legs, how I can stand up? Therefore, the initiation of this criminal proceeding is a gross manifest error of law, is without jurisdiction, but is purely to take vengeance, and we have given all the references. But that can even point it out to me, or already pointed out, why a criminal proceeding should be called at the very point of time. Well, I have given that judgment before the lordship. This is number one. So far, case number 340 is concerned, well, he was arrested by Lord on 13th of November 2013. But he was in custody. Case number 340, second case. Well, I have analyzed everything in my short notes of argument. And even can 4. Well, he was soon arrested. Well, there is not a single statement behind anywhere to show that cause of arrest, the reason for arrest, which is the main criteria of Article 226 of the Constitution of India, as has been envisaged in the recent Supreme Court judgments. In both the cases, there is no material. Connect me with the alleged offense. Well, in the second case, there are 42 witnesses. Charge has been framed in case number 340. There are 2 witnesses, namely the photographer or something else has been examined. Well, nothing else has happened. The date of charge sheet is 11th of February 2014. There is nothing to progress. Well, this is also, they have not stated anything so far their reply is concerned. They have just portrayed the allegations of the charge sheet in their affidavit in opposition, showing me as one of the conspirators. Well, what is the conspiracy? Well, I have already shown to your lordship. একটা কপি দাও, একটা কপি আমাদের দিন স্যার, একটা কপি তোমাকে দাও আর একটা কপি আমাকে দাও। Well, they have shown 2 witnesses as a that I have conspired. Well, so far case number 340 is concerned, date of arrest November 27, 2013. When the statement was recorded after 2 months, 22nd of 11, what is the position? That I was standing in front of a delight student. But I had submitted bureaucracy on the other day. If I gossip, my lord, what is it? On the street, if I gossip, suppose my lord in the college square, and if the incident happens within the my lord coffee house, can I be implicated? And when? Well, he is a driver of Mamta Agrawal. The place of occurrence is within 5 minutes. Shakespeare Swanee PS matter is within 10 minutes. Why matter he will be examined after 2 months? And the next statement is matter Nur Islam, caretaker of the arrest premises. He was also examined after 2 months. No reason has been given. And my lord, I had, my lord, possibly forgotten to give you a judgment. My lord, judgment down. Paragraph 5 is the paragraph 5. Only can you see this? What is the effect of non-compliance of recording the statement of the witnesses after a long gap, after 8 days, after 2 days, or after 22 days? Is it criminal conspiracy? Next case is 314. Well, it's a simple case of 323 and 324. Date of initiation is, my lord, 19th August 2013. He was arrested, my lord. Look at it, after 6 months on 6 January 2014, although I was in custody. What is the reason behind it? I am in custody. The date of incident is 2013. Date of arrest is January 6, 2014. Charge sheet has been filed in 2013. After 4 days, the charge sheet was filed. Nothing has happened. Nothing has happened. And my lord, can you see, my lord, in my written notes of argument, I have explained each and every point which they have not complied with or which they have not replied. Is it not absurdity? I am in custody. Before 6 months, the incident is happening. They are not arresting me. And thereafter, they are initiating this case. One after another, my lord, they have implicated me, destroyed my career and my fundamental rights. The last case, we are at Anandpur PS case number 188. That's the last case. It's a case of cheating. The complainant has alleged that he was one of the directors of the company. He was induced by somebody else, and my lord was acquainted with the present petition. He became director of the said two companies. He had invested money in the said two companies of rupees 64 lakh, something like that. The company has suffered the loss. Now he has complained that I have cheated him, I have defrauded him. Although the checks were in the name of the companies. I was one of the director of the two companies. I had suffered a loss. Thereafter, I had resigned. Then I had complained. And even without making the company a party, whether that case can be proceeded with. But that case has also been submitted in 2014. Charge sheet has been submitted in 2014. 12 years have gone by in the meantime, nothing has progressed. I have given graphic description in my Can 4 of 2025, as also in my written notes of argument. And now my learned friend will tell me. Can you give us only that liberty? So I can rebut that, my learned
Yes,
friend.
yes, certainly.
I'm getting.
No, my lord, it is only because of my learned seniors' huge fixed deposit of experience that he can underplay the entire incident which has happened at 9A Short Street. Now, my lord, luckily, my lord, I have seen the papers, but much before seeing the papers, we have all seen this and remembered this from the newspaper and the media, what happened at 9A Short Street, which ultimately culminated into an incident of 2 persons dying and 2 persons getting injured due to firing inside a kindergarten school. My lord, the entire incident is because of a fight over this property 9A Short Street between two groups. One is the group of Mamta Agarwal and Ratanlal Nahata, and the other group is that of the petitioner, where the petitioner is one of the co-conspirators in creating this fight between the two groups, which has ultimately culminated into the incident of 13th of November 2013. Now, my lord, I have created before taking your lordship through the papers, my lord, I have created a short and very simple flow chart. My lord, kindly read it with deemed arrows. Duto copy koreche. I will just 1 second. Sir, আমি একটু পড়ে নিই আপনাকে। Well, it is without arrows, but it's in a nature of flow chart, and everything, my lord, I'll also show from the papers just to give a brief understanding of the facts. সৌভিককে বল এটা সফট কপিটা আমাকে হোয়াটসঅ্যাপ করে দিতে। না না, যেটা পড়ছি ফ্লো চার্টের সফট কপিটা সৌভিকের কাছে আছে। The subject property originally belonged to one Rajendranath Shai, the admitted owner, original owner. Rajendranath Shai expired on 1999. Upon his death, the property devolved on Shoilobala Shai, who inherited the same. Then, my lord, the first transfer takes place. On 22nd June 1999, Shoilobala Shai executed a registered sale deed in favor of Heartline Estate Private Limited. And this sale deed, my lord, was executed on the strength of a power of attorney, which was executed in favor of one Shivaji Banerjee. In connection with this, then the second transaction is, my lord, point number 3, the subsequent will. In the 2003, Shoilobala Shai executed a will in favor of Rakhi Shai and Rumi Shai. But all these Shai will be SEIN. There's a spelling mistake in my notes. Shoilobala Shai, my lord, expired in 2008, and the will was never probated. Yet, my lord, on the basis of that unprobated will, kindly take the next point. In 2010, Rakhi and Rumi executed a sale deed in favor of Ratanlal Nahata. There is a second branch of transaction.
Did Shoilobala have any other heirs apart from
No, only two granddaughters.
these two?
Two granddaughters.
Cannot be probated. Assuming it is not probated, they inherited.
They inherited, and it was sold to Ratanlal Nahata. It's the second branch of transaction of the same property. First one
yes,
goes to
yes.
Heartline Properties. Then in 1999, in the year 2010, Heartline Estate executed a sale deed in favor of Sanjay Surekha for a consideration of 8 crores. The said deed records Parag Majmudar as the confirming party, that's the writ petitioner. Out of the total consideration, approximately 7.13 was received by Parag Majmudar. The balance amount was received by Dilip Das and Rajesh Damani. Then the dispute. Parag Majmudar came into contact with Samir Reyes, an advocate, Partho Chatterjee, an advocate, and Pinakesh Dotto. With subject to correction, all these are represented before your lordship. All these three in separate addition of party applications. Then an attempt was taken to forcibly take possession of the property on 19th of August 2013. This is the origination of the first FIR, 314 of 2013, lodged at the Shakespeare Sharani police station. The second attempt was made on 15th of September 2013, which culminated into FIR number 340 of 2013, was lodged in the Shakespeare Sharani police station. Meanwhile, Ratanlal Nahata continued to make representations to the authorities and install CCTV cameras at the premises. Then, my lord, kindly turns over the incident of 11th November 2013. On 11th November 2013, Samir Reyes, Partho Chatterjee, and Pinakesh Dotto visited the premises along with bouncers. The bouncers allegedly scaled the boundary wall and opened the gate from inside. During the incident, a blank fire was allegedly made. Subsequently, Mamta Agarwal fired a double-barrel gun towards the hut structure. But these people, Mamta Agarwal's group, came out with rods and sticks. The bouncers scaled the wall at 4 o'clock in the morning. But opened the gates, more bouncers came in. When the people inside came to know that many people are out inside, they got sticks and rods and tried to chase them. It's a nature of a kindergarten school which is having small huts for kids. 2 people went and hid behind the small wooden hut. That is what the hut is referred to. Subsequently, Mamta Agarwal fired a double-barrel gun towards the hut structure. 2 persons died, 2 persons got injuries. A criminal complaint was filed leading to registration of FIR number 397 of 2013. This is filed, the complainant is the staff of Mamta Agarwal. That is Shafiq Ahmed. And Shafiq Ahmed was named as an accused in another FIR where 302 is there because of the death of the two persons. That is FIR number 398. Of this, the petitioner is not asking for quashing. And apart from the above, as I have already submitted 314, and as my learned senior submitted, another case of Anandapur FIR number 188 is also there. Noor Ali recorded the statement of Shafiq Ahmed in connection with FIR number 397, in which Shafiq Ahmed was the complainant. It later transpired, Noor Ali is our officer of the police station.
All right.
It later transpired that Noor Ali was allegedly linked with Samir Riaz, Partha Chatterjee and Pinakesh Datto. On 10 November 2013, a false journal diary entry was allegedly made by this Noor Ali. Noor Ali was arrested. He was subsequently granted bail. Partha Chatterjee made a statement under section 164 of the CRPC before the learned magistrate. And the last entry is the charge sheet of 5th of February 2014. So this is the flow of events. Now, Malad, to put this to context, this flow chart, Malad, I'll show the text of the charge sheet filed in 397 because it encapsulates this entire event in Malad as a charge sheet. But before that, what is relevant is that Malad, this delay which has been harped on, I'll just address that point. With regard to Shakespeare Sholoni PS case now, before going into the merits, I should get over all these technical points of delay, etc., no steps taken. We have prepared a chart. We had prepared, when your lordship was sitting at court number 14, we had prepared a chart that is up to February 2025. We have a chart of 114 entries from 9th of January 2015, that how this matter got adjourned for this 9 years. And we have found that the defense counsel, that is my learned seniors client's counsel there, has taken an adjournment on 37 occasions before the court below. The prosecution has taken an adjournment on 6 grounds, 6 times. On 9 occasions, there was a resolution of the local bar for not to attend, not to pass adverse order, etc. And 17 times due to the transfer of the presiding officer of the court. And 3 times due to the COVID. So, Malad, that is how 9 years has gone by, and in the middle, there was a quashing by the Supreme Court. Then state went up, filed an application for recalling of that. Because of the Supreme Court quashed all the FIRs, the court below also discharged the accused. Then again, Malad, the case was restored in the learned court's file. So, Malad, I have prepared this chart. Kindly takes 114 dates. Malad, your lordships need not go into all the dates. Malad, your lordship at the end will find the summary that I have already just read out. And here your lordship will find also that they have made application before the court below. They made applications before the court below for procurement of the CCTV footage. They made application before the court below for their discharge also. So all these applications are already there before the presiding officer of that court, which the petitioners need not trouble your lordships with because they have already availed of the alternative remedy. So, my lord, what will actually be left with is a scenario, 3 options, 3 end results. One is that if your lordship finds that the FIR, for each, is required to be quashed, then the entire proceeding goes. That's option 1. If your lordship finds that the charge sheet is perverse or wrong, your lordship within the parameters of quashing of charge sheet, then the FIR remains, the charge sheet goes. And I continue with the investigation or whichever way it culminates. And the third thing is that your lordship finds the offences made out in the FIR, the charge sheet appropriately filed, including the name of the writ petitioner, and your lordship dismisses the writ petition. In that case, the trial will go on. So these are the 3 scenarios. So, my lord, but if your lordship will kindly allow me to place one complaint at a time and then the charge sheet at a time to establish that the petitioner had an involvement in each of the three occasions. But chronologically, I should start with FIR number 314. But my lord, kindly allow me to start with 397 because the charge sheet in that has all the facts. My lord,
Was this prepared 1 year back?
yes, my lord. When your lordship is sitting in court number 14.
Because I see the date of 14th of February
2025. Thereafter, the matter, my lord, did not come up in the roster for a long time. So I'm sure it will only addition of dates have occurred.
Yes, yes.
My lord, we have filed a supplementary affidavit
Yes.
just to bring on record the complaint and the charge sheet in each of the cases. Now, my lord, before taking your lordship to the merit of the cases, one thing I must point out that out of the 4 cases, in 2 cases, cognizance has been taken and the trial is going on. And in 2 others, that is 188 and 397, cognizance has not been taken. So, my lord, those 2 are in a different footing, and 314 and 340 are in a different footing. Because, my lord, as recent, my lord, as on 3rd September 2025, the Honorable Supreme Court has clarified that if cognizance has been taken, that, my lord, amounts to passing of judicial orders by the court below. Under 226, your lordship will not be permitted to interfere with the judicial proceedings which is before the court below. And, my lord, the court has categorically held and distinguished its own decision in Nita Singh, saying that if petition is filed under 226, read with 482, it is permissible. But if it is only under 226, then it is not permissible. I'll place those decisions, my lord. This is 25th September 2025, the decision has been rendered. Now, my lord, kindly
Here
take
is the petition only under 226 or 482 has
only 226, my lord, as
482 is
not there, my lord.
yes.
Now, my lord, the complaint in this, my lord, is at page 6 of the supplementary affidavit,
397.
397.
Yes.
Supplementary affidavit. Your lordship has found the supplementary.
Yes.
My lord, if it is not legible, my lord, in your lordship.
Can read it.
Yes. My name is Shafiq Ahmed. My nickname is Pappu. I am so and so years old. My father's name is so and so. My address is so and so. But I live at 9A Short Street for the last 8 years and work for Ratanlal Nahata and Mamta Agarwal. And they have appointed me as caretaker of 9A Short Street. There is a school, kids school, styled as Young Minds International School, for which Mamta Agarwal is the principal. Ratanlal Nahata was admitted to Apollo Hospital with some serious problems. He was released on 10th November 2013. As he could not move and walk on his own, he was shifted at the office room of the Young Minds International School, 9A Short Street. For his take care, Mamta Agarwal and myself were staying at the night of 10th November 2013 and 11th November 2013 to feed him with oxygen and for the medical attention. For the last few days, we were receiving calls that we were going to be attacked and evicted from this land. So we had installed CCTV cameras inside and at the gate of this property. The monitor is in the office room. We also posted 2 security guards all along the main gate. While we were sleeping on 11th November 2013, we woke up around 4:40 a.m. at the hue and cry and at the sound of opening of the main gate. Mamtadi went of the room to see what was happening and then instantly came back. She told that we are under attack. I also came out and saw 10 to 12 persons, including few ladies, assembled in the compound, and they were armed with sticks and iron rods. In the meantime, Pramod, who was sleeping at the school room, name lawn to in something. We took sticks and chased them, but some of them were not leaving our premises. So we took the licensed guns of Ratanji and chased them. They ran away and they took shelter inside the wooden hut, and some went out of the property. If I would not chase them, they would not have harmed. Then Mamta Di called police and police came. Please take necessary action. Now, my lord, thereafter the FIR is there at page 8, and your lordships will find that the writ petitioner is not an FIR name accused in this FIR. It is only in course of investigation that his involvement was found out. My lord, the charge sheet dated 5th of February 2014 is at page 10, starting at page 10, and your lordship will kindly turn over to page 36. 35. 35, your lordship will find that in the charge sheet, Parag Majmudar was named as the accused person, 11K. Now, my lord, his connection with this entire incident, my lord, I'll have to read from page 51 onwards. But my lord, I'll require some time to read. It's a longish charge sheet. May I start today, my lord?
It's already 3:30 nearly.
That is why, my lord. Or, my lord, I can come back on Friday, my lord. My lord, at page 53 bottom, last two paragraphs, only as a cursory look, your lordship will find the 2 paragraphs dedicated to the writ petitioner, showing his involvement. Also at the top paragraph, bottom part. So, my lord, as I was saying, the way it was underplayed by my learned senior, that on the opposite hand, I was standing and having a tea. But if I could have a tea on the roadside and earn 7.13 crores, I would love to have tea every day. A person goes opposite a kid's school, has tea, and earns 7.13 out of a land transaction. That is how my learned senior underplayed the entire incident, my lord.
So we continue it on next Friday.
Friday, my lord. But may it also be marked at 2 p.m. as it
2
was.
p.m.
2 p.m. করে দিচ্ছ তাহলে একটা নোট কাগজটা যে শরীর না ভুলেই যাবে
Standing Counsel of the state commences argument but does not conclude the same. Stuff fix on 20th Kuri at 2 p.m.
Get to you.
দেখায়নি তো